I don't know. I didn't
yeah.
want to make another run back to my desk.
Yeah, I'm good. So I usually make 2 sets. I have my old set that I made years ago, and I just added because I already had these from a long time ago. And then I have. Will do. Okay. Yep. So I washed it.
I got mushroom. I made my own. Like, no, so it's like spicy and it's real.
I will now recognize myself for an opening statement. Thank you. Good afternoon and welcome to the House Judiciary Subcommittee on Courts, Intellectual Property, and the Internet's hearing on oversight of the United States Patent and Trademark Office. I'm pleased to welcome the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, Iancu. This is his second appearance before the committee. He was first before us on May 22nd, 2018, a few months after he was confirmed on February 5th. Today's hearing will elicit critical information regarding the state of the agency and in response to the questions that we will ask. Intellectual property is of vital importance to the U.S. economy. For example, economists have studied the impact of the award of a patent to small businesses, concluding that the award of the first patent to a startup on average leads to 16 additional employees after 5 years and $10.6 million in additional sales over 5 years. But businesses of all sizes have also come to Congress raising concerns about lawsuits based on patents they believe should not have issued, causing them to spend money on lawsuits instead of R&D. This gets to the heart of the key question that drives patent law policy: how to balance the many competing interests to ensure that the patent system incentivizes and promotes innovation to the greatest extent possible. This is the discussion I hope to have here today. A strong patent system starts with a country that creates and encourages the next generation of innovators. This subcommittee's first hearing examined research showing that we are falling behind in this task because our patent system demonstrates a lack of diversity in who is getting patents. The USPTO recently issued a report showing that only 12% of U.S. inventors are female. Thanks to the passage of the Success Act last year, the USPTO is following up on this report with further research on underrepresentation of other groups, including racial minorities and veterans, in fulfillment of the provisions of the Success Act, a bill where I was the lead Democratic co-sponsor, along with Representative Steve Chabot. This is important work. Fully understanding the contours of underrepresentation is an important step in designing policy that can ensure that as a nation we are not leaving potential inventors behind and groundbreaking innovations undiscovered. A strong patent system requires clear rules which lead to reliable patent grants that attract the investment needed to turn a patentable invention or innovation into a marketable product or service. I have concerns that a foundational section of the Patent Act, 35 U.S.C. Section 101, which governs patent-eligible subject matter, is not delivering this needed clarity due to a series of recent Supreme Court cases. This poses a threat to innovation in critical technologies such as medical diagnostics. We in Congress are considering whether we must take action. Meanwhile, the USPTO has recently tried to address this problem at the agency level with new examiner guidance. I hope we will be able to learn more about that initiative. Director Iancu has also made a number of changes to the post-grant procedures created by the Leahy-Smith America Invents Act of 2011, including changes to the trial practice guide, the creation of 2 new standard operating procedures, rulemakings on claim construction and claim amendments, and the issuance of a significant number of binding agency opinions in recent months. I know that stakeholders have a range of opinions on these proceedings, their fairness and effectiveness, and I look forward to hearing why these recent changes were needed and the impact that they have had. Turning to trademarks, I'm alarmed by reports of an increase in fraudulent trademark applications, especially the large number coming from China. This means that American businesses might not be able to register marks they are actually using, hurting their ability to establish their brand and grow their businesses. I'm also concerned about reports that companies are illicitly using the trademarks of reputable companies to sell counterfeit goods. I would like to hear what the USPTO has done to address this so far, what else it plans to do, and what role Congress should play to ensure the smooth and fair administration of intellectual property rights in this country. Director Iancu, thank you for coming here today, and I look forward to your testimony. It is now my pleasure to recognize the ranking member of the subcommittee, the gentlewoman from Alabama, Ms. Roby, for her opening statement.
Thank you, Chairman Johnson, and thank you, Director Iancu, for testifying before the subcommittee today. America continues to lead the world in the development of new technologies, from immunotherapies that save lives to the apps that answer our questions with just a few swipes of our phones, to novel inventions that make our lives better. The patent system is key to the United States remaining on top. A strong patent system helps to encourage robust investment in the development of new technologies. If research produces a valuable invention, companies know their patents will safeguard that investment and the invention from bad actors. To eliminate fraudulent patent litigation, Congress and the courts made several changes to patent litigation rules and legal standards. There's been much debate in the patent community as to whether these changes have been beneficial for the patent system. For example, some have criticized the U.S. Supreme Court's patent eligibility test as undermining the reliability of patents in certain critical U.S. industries, including medical diagnostics and data compression. Today, I hope to hear Director Iancu's views on the patent eligibility test, whether the USPTO's guidance on the issue is sufficient to address concerns, and if he thinks Congress should act, his expert advice on a possible legislative fix that would work for all interested stakeholders. One of the most significant recent changes to the patent system was made in 2011 when Congress passed the America Invents Act. This legislation established the Patent Trial and Appeal Board, commonly referred to as the PTAB, and inter-parties review proceedings known as IPRs. These new procedures authorize the USPTO to consider challenges to patents and to withdraw improperly issued patents. The process was intended to be a simpler, cheaper alternative to district court litigation. There's been much debate since establishment of the PTAB and the IPR proceedings about whether these changes have been good for the patent system. Opponents of the PTAB argue that IPR proceedings make it too easy to invalidate a patent, pointing to high invalidation rates for patents that the agency agrees to review. They argue this casts a cloud of uncertainty over all issued patents and that this uncertainty discourages investment and contradicts the very purpose of the patent system. One persistent concern has been the repetitive filing of similar challenges to patents by the same or related parties. Proponents of the PTAB argue that changes to the patent system were necessary due to poorly drafted and overbroad patents that were being used in abusive litigation. They argue that the PTAB has been successful in its original intent by removing bad patents from the patent system. The USPTO needs to ensure that challenges are not being used to harass patent owners while still effectively weeding out bad patents. But in considering any tweaks, we must ensure that a proper balance is struck, protecting companies from abusive litigation while ensuring patent owners' rights. There are also two trademark issues that I would like to explore with Director Iancu today. First, the sale of counterfeits online appear to have become a significant problem for trademark owners. The problem is so pervasive that just over a month ago, the President issued a memorandum ordering that the Secretary of the Department of Homeland Security to work with several other cabinet members and agencies to investigate and issue a report on the problem. As the head of the agency that issues trademarks and participates in anti-counterfeiting efforts, I would like to hear from Director Iancu's views of the problem and possible administrative and legislative solutions that Congress and the White House should consider. Secondly, I want to hear from Director Iancu on steps the agency is taking to address fraudulent trademark applications filed from overseas and what, if anything, the agency is doing to remove registrations that were improperly granted by USPTO. I would like to again thank Director Iancu for his participation in this hearing, and I very much look forward to delving into these very important issues. Thank you.
Thank you, Congresswoman. I'm now pleased to recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, today's hearing focuses on what has been a time of great change to our innovation landscape. In 2011, we passed the most significant changes to the patent system in a generation with the America Invents Act, known as the AIA. As patent stakeholders were still adjusting to that, the Supreme Court issued a series of decisions on patent-eligible subject matter, dramatically changing how the relevant statute, 35 U.S.C. Section 101, impacted both patent examination and patent litigation. And these are only two of the biggest changes in a time when the patent system's importance to American competitiveness has arguably never been more crucial to our increasingly knowledge-based economy. When this subcommittee held its last USPTO oversight hearing, almost exactly a year ago, Mr. Iancu had only recently been confirmed as the USPTO director. Now that he has been director for over a year, we have the opportunity to discuss what new policies his office has implemented, where the patent and trademark systems stand today, and what role Congress needs to play to ensure that these systems are organized for our nation's innovators and entrepreneurs. Turning first to the AIA, an important element of that legislation was the creation of procedures to challenge a patent's validity after issuance by the USPTO. The most used procedure, the inter partes reviews, or IPRs, have proven extremely popular and now handle around 1,500 cases a year. Because IPRs are now such an important part of the patent landscape, they have garnered much attention and of both supporters and critics. Congress intended IPRs to be a faster, more efficient way to challenge patents. The question before us now is how well these challenges are meeting that goal, and what impact have they had on the overall patent landscape. To that end, Director Iancu, during his tenure, made a series of changes to the Patent Trial and Appeal Board, or PTAB, which hears these IPR challenges. To me, these changes raise the question of whether Congress delegated the right amount of rulemaking authority to the USPTO to adjust these proceedings over time. I worry that an adjudicatory process that changes too much with any change in agency leadership. I worried about such an adjudicatory process, I should say. I look forward to the Director's thoughts on how we can ensure stability and predictability at the PTAB. I also want to learn more about how IPRs have impacted the overall patent landscape. I understand from many stakeholders that they have succeeded in providing a less expensive way to challenge patents that should not have been issued than challenging in district court. At the same time, some stakeholders are concerned about the impact on some patent holders' ability to enforce their rights, now that they may need to go through an IPR proceeding before a court will hear their infringement claim. Additionally, as most IPRs have parallel litigation in district courts, some ask whether the AIA lived up to its promise of delivering more efficiency, or if it has simply fostered duplication. Another topic in which Director Iancu has taken action is on patent-eligible subject matter. He recently issued new guidance to patent examiners that distilled the existing case law into a streamlined test. Rather than have patent examiners, most of whom are not lawyers, thank God, essentially apply a case law approach when assessing this issue. While this move is understandable given the need to provide clear guidance to 8,000 plus patent examiners, the USPTO does not have rulemaking authority in this area. And so the question is it improperly exercising what amounts to rulemaking authority, or perhaps we should give it rulemaking authority? I am curious, therefore, about the process used for distilling the case law into guidance, especially given that some of the case law seems to be in conflict. Most importantly, I am interested in how the USPTO is ensuring that the patents it issues deserve the presumption of validity with respect to this issue, if there ends up being a clear divergence between the USPTO's guidance and the Federal Circuit. Without doubt, Director Iancu has the reins of this agency at an important time. The United States is a world leader in innovation, which is a key driver of economic growth. His stewardship of the USPTO is vital to ensuring that the United States remains in this position. I look forward to his testimony, and I yield back the balance of my time.
I thank the gentleman, and at this time I recognize the distinguished ranking member of the full committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. I appreciate that. And Director, thanks. It's good to see you. I feel like we see each other quite often at events lately. It's good to see you, though. And thanks for testifying, because this is an important part. This is really, frankly, of all the things that we do in this committee, is one of those areas that I believe we find some of our common agreement and our greatest gains if we just simply put our mind to it and say, how can this affect? This is also probably, although it is much less publicized as many of the other things in our committee that we do and doesn't get the press that it deserves, this is the thing that actually drives and focuses our economy in ways that many of us in this room could never imagine and have been talking about for years, because I believe the very things that your office deals with and the very things that our patent and trademark office continues to work with really determines where we're going to be in the coming years, whether it be in technologies that already exist or the technologies that we couldn't even think of at this point. So again, I just want to think about that. And and when we celebrated World IP Day, I think it all just emphasized, really those things that we all can come in agreement on. I'm hopeful, Mr. Chairman, as we work through these things, this will be something that we focus on a great deal in the future. However, just like the chairman, there are some things that I think we're discussing and want to continue to talk about, and that's making sure that the patent litigation abuse problem is something we continue to look at, but also make sure that it is fair not only to all patent holders, small, medium, and large, but also make sure that there's an easier system in which there's not just a constant, what I'll call circle of litigation, circle of problems, in which there's never a surety of that content or that patent owner actually having something to be valuable. One of the areas that I do want to talk about, and I know we'll talk about today, is the patent eligibility issue, and of course that is the 101 discussion. Supreme Court has basically put us through, Director, as you well know, a tortured exercise and called on the courts and Congress to fix it. The way they've come about it, especially with the opinions of the U.S. Court of Appeals and the Federal Circuit, the highest patent court in the land, and next to the Supreme Court, in which at least 5 of the expert judges there complained that the test is flawed and must be replaced, okay? We cannot sit back and continue to watch our mighty patent system, a key driver of this innovation, continue its slide. That's why myself and several of colleagues in the House and Senate, including my friend Chairman Johnson and numerous stakeholders, have been investigating to develop a patent eligibility test that works for all. Another area of the patent system that requires our attention is the USPTO's implementation of the inter-party or IPR proceedings. It's been 8 years since we established those proceedings, and they've both been heralded and vilified all at the same time. I know that's not surprising to anybody from this committee. But many are happy to avoid the costly patent dispute in a federal court instead of rely on the PTAB to quickly and less expensively invalidate an accuser's patent. But others argue that the PTO has implemented countless rules skewed against patent owners that result in good patents being struck down in bad IPR decisions. I have heard numerous reports that defendants in litigation are filing multiple similar attacks on the same patent or are using surrogates to skirt prohibitions to repeat attacks. I've also learned that since in instances where small businesses sought to assert their patents in federal court to stop the theft of their valuable IP, those thieves instead are forced to defend themselves. From those thieves, they're forced to defend themselves and their patents before a PTAB, which issued a questionable decision invalidating the patents. Fortunately, some of these small innovative companies could afford to appeal the PTAB's flawed decision and have their patents restored by the federal circuit. But this demonstrates the PTAB proceedings may be used by well-funded companies to harass small businesses in submission. The cost for appealing a bad PTAB decision may be too much for small businesses to bear, resulting in their loss of their patents, their innovations, their business, and at the hands of an unscrupulous copycat. Again, very thing that we're trying to avoid, we're actually seemingly incentivizing, and that's something that we need to look at. In this hearing, I want to hear about these concerns. I want to know about the patent eligibility test and how we should craft it to promote investment in important technology industries while avoiding a resurgence of patent litigation abuse. No one wants to go back there. But we also can't have a system that incentivizes an incessant going back and forth, or what I'll just call a circular, never being sure is my patent worth what my patent is supposed to be worth. If we ever lose that in this country, if we ever get to the point to where our patents and our copyrights, our trademarks, the very thing that really has based our intellectual property exercise on for well over 200 years, if we get to that point to where that doesn't matter, then we will go backwards economically, we will go backwards in the world, and we will have our brain drain is what I will call it, that hope drain will go other places where it is protected. The reason we have the greatest economic system, especially involved in IP and all of these other decision makers, is we protect our IP. Strong intellectual property protection is not a hindrance, it is the very catalyst to growth. It is the very catalyst to our economic engines. And with that, I look forward to this hearing. I thank you for being here. It is always a pleasure to see you. And I appreciate the work that you've been doing in this area of to find a solution. and to not just simply wait and say, well, whatever Congress does, I'll work. You've been able to take some of that initiative. That's a good thing to see, because I think you've been taking all the players into that role as we go forward. With that, Mr. Chairman, again, thanks for calling us here, and this is, again, a good time for this committee, and I appreciate you calling. And I yield back.
Collins, for your remarks. I'll now introduce today's witness. Andre Iancu currently serves as the Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office. Andrew Iancu provides leadership and oversight to more than 12,000 employees with an annual budget of over $3 billion. He is also the principal advisor to the Secretary of Commerce on domestic and international intellectual property policy matters. Prior to joining the USPTO, Director Iancu was the managing partner at Irel and Manella LLP, where his practice focused on intellectual property litigation. He has also taught patent law at the UCLA School of Law, and earlier in his career was an engineer at a Hughes Aircraft Company. Director Iancu holds a JD from the UCLA School of Law, an MS in Mechanical Engineering, and a BS in Aerospace Engineering, both from UCLA. We welcome Director Iancu and thank him for participating in today's hearing. Before proceeding with testimony, I hereby remind the witnesses that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to penalties of perjury pursuant to 18 U.S.C. Section 1001, which may result in the imposition of a fine or imprisonment of up to 5 years or both. Please note that your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals that your 5 minutes have expired. Director Iancu, you may begin.
Thank you, Chairman Johnson, Ranking Member Roby, Chairman Nadler, Ranking Member Collins, and members of the subcommittee. Thank you for this opportunity to discuss the operations, programs, and initiatives of the United States Patent and Trademark Office. I would like to highlight some issues of particular interest. First, we are pleased that Congress continues to provide the USPTO with access to all anticipated fee collections, which is critical to our ability to plan and provide certainty to inventors and entrepreneurs. Second, as part of the USPTO's efforts to reach all potential inventors, in February we issued a new report which found that while there have been gains in female participation in science and engineering occupations, those gains have not led to comparable increases in female inventors awarded patents. The USPTO is committed to working with industry, academia, other government agencies, and Congress to help broaden the innovation ecosphere demographically, geographically, and economically. I would like to thank this subcommittee for holding a hearing on this issue last month to highlight the problem. For our part, the USPTO has targeted programs to increase participation in STEM and intellectual property for women and other underrepresented groups. For example, is just one of many programs the USPTO will host on May 14, its annual Women's Entrepreneurship Symposium in Alexandria. The USPTO also recently updated our website to better serve new inventors and entrepreneurs. Now, with one click, visitors are directed to a US map where they can find a multitude of free resources in their area to better help them navigate the patent and trademark system to protect their intellectual property. We continue to update these materials. Third, regarding patent operations, last year I testified that we would improve the conduct of AIA trials by our Patent Trial and Appeals Board. I indicated that we were studying, among other things, claim construction, the amendment process, the institution decision, the composition of judging panels, and a variety of standard operating procedures. I'm happy to report that we have implemented successful improvements in all of those areas. I also testified that the USPTO would work to provide guidance for examiners and the public regarding the issue of patent eligibility pursuant to Section 101. I'm happy to report that we have done that. The new guidance synthesizes the relevant case law, clarifies the eligibility analysis, and I believe will lead to more consistent results. By now, virtually all of our examiners and administrative patent judges have been trained on this new guidance, and the results to date have been excellent. And this is good news, because the status quo ante, prior to our recent guidance, is no longer tenable. If the United States is to maintain our technological edge in an increasingly competitive global environment, the American patent system must move beyond the confusion of the past several years when it comes to this most fundamental question in the patent system. What matter is eligible for patent and what matter is not? I believe that the framework we laid out in our recent guidance works well and goes a long way towards solving the predicament we have found ourselves in. I hope that other authorities will join us as we continue our efforts to bring clarity to this critically important part of our patent system. I commend the Congressional Working Group for its efforts on this issue, and the PTO stands ready to help with the legislative process as needed. Fourth, on the trademarks front, we published a notice of proposed rulemaking in February that would require U.S. license counsel for foreign domiciled applicants. This should help reduce the number of potentially bad faith trademark applications from overseas filers. We are also studying other options for decluttering our register and may also consult with Congress regarding possible legislative tools. Finally, on the operations side, we have recently hired an experienced Chief Information Officer, and we continue to work to improve our technology infrastructure. Mr. Chairman, the USPTO is a remarkable agency with a dedicated nationwide workforce. I am proud to be part of it. Thank you again for the opportunity to testify today, and I look forward to your questions.
Thank you, Director Iancu. I'll now recognize myself for questions for 5 minutes. Director, I'm concerned about the lack of consistency and predictability in the case law applying 35 U.S.C. Section 101. What is your view on how the case law is impacting American innovation?
So, as have been mentioned by yourself and other members already, and in my opening statement, court decisions have created uncertainty. There is no workable framework or workable test provided by the case law, for example. So this has created confusion for our 8,500 examiners who have to apply the law and the cases every single day, and for our applicants and members of the public. That situation, simply as I said, is not tenable. So the PTO has synthesized the case law and has created the framework that I've mentioned. And I can go into more details if you'd like.
Well, yeah, if you would.
Yeah, so the framework that we have created is a synthesis of existing law, and it's really working great for at the Patent Office because it provides guidelines for the examiners to apply in a consistent manner, and it provides a system that's understandable by our applicants and other members of the public. And the fact of the matter is that we have received lots of comments on this across the spectrum. As a general principle, with very few exceptions, people across the technological spectrum agree with the framework. Some folks might disagree whether some particular type of technology should be in or out of the eligibility system or not, but generally speaking, the framework, which is the most important thing, folks seem to agree with. Now, the bottom line is courts are independent, and they don't have to follow our guidance, obviously, and our framework. I hope they would, frankly, because it's correct, I believe, and there is broad-based support, as I said. It goes a long way towards solving the problem, but they have not yet provided clarity. So, bottom line is, if Congress desires to create more certainty, legislation is needed.
Thank you. I'm also concerned about the rise of fraudulent trademark applications. While I think the USPTO's recent proposal to require U.S. counsel for foreign registrants should help as we move forward, this will not help the thousands of fraudulent marks already on the register and that are blocking legitimate companies. What is your plan for addressing this problem?
So this is, you've identified a significant problem. It's an increasing problem. It is a lot of it caused by foreign applicants. Not all of it, though, to be clear. Not all of the entirety of the problem is foreign. Some of it comes from here. But we have done a number of things and can do more. For example, first and foremost, we're having increased training of our examiners to be able to look for and spot troublesome applications. We have advanced training, for example, set for this June coming up on spotting and handling possible fake specimens. We have increased the proof of use audit program. We have piloted an expedited cancellation process. We are piloting software that can help detect photoshopped images. And as I've mentioned in my opening, very important, we issued a U.S. Council proposed rule which would require foreign applicants to use U.S. licensed counsel for their trademark applications. Hopefully, U.S. licensed lawyers would be more reluctant to put in fraudulent applications. And if they do, at least we have an address to pursue. As I said, there's more than that we could do. We're looking at all of it. We have a task force. There are new rules and processes that we can deploy. We can, for example, address a specimen definition. We're working on that. We can work with Congress on potential legislation, for example, legislation for lowering the threshold for cancellation of false claims of use to negligence. These are preliminary ideas, by the way. We're still working on them, and we'd be happy to consult with Congress when the time comes.
This is a law firm of Johnson & Johnson today. We'll just tag team.
It's easier for me to remember this.
That's right. You can't mess this up. Director, we really appreciate you being here today, and thank you for that summary of what you presented and all that you've been able to accomplish. You have a gigantic task at hand. We recognize that, and we're thankful for you and your staff. I know you have a lot of folks with you and watching today. Just a few questions. Look, I regard your office and your work to be among the most important in the government because I believe that property rights are fundamental. It's a natural right that we have to own property and to protect it. And so what you do is so critically important to our entire system, our free market, and everything that we're about as Americans. So thank you. A couple of questions. Based on comments you provided in your written testimony, you highlighted the USPTO's involvement with the Patent Prosecution Highway, PPH, which facilitates patent approval amongst trading partners. I represent a district located in Louisiana, the 6th largest export state by value in the nation. And I'm encouraged by PPH participation with nations like Brazil and others because they're essential to my state's export economy. So the question is, has the USPTO undertaken any steps to expand cooperation through PPH? And if so, what countries have you targeted to include in that?
The answer is yes. We continuously look to first strengthen our relationships with IP offices across the world, including the ones we already have agreements with on IP, and we're looking to expand the list. Unfortunately, I don't have off the top of my head right now who else we're talking with, but happy to provide that in writing. There's always an effort afoot to expand PPH and our collaboration with various offices. I personally meet with my counterparts from across the world regularly, and will continue to do so.
We appreciate that. I know they do as well. In your capacity providing technical support to the Department of Commerce and the U.S. Trade Representative on proposed and ongoing trade agreements, could you speak briefly as to what recommendations you've made in agreements like the USMCA and what you'd like to see included in IP chapters going forward?
So we do provide technical advice to various agencies across the government when it comes to intellectual property. We do get involved if we're asked to advise the Secretary of Commerce and others at the department, and also the USTR. We did provide technical assistance to the USTR during the USMCA and other trade negotiations. As a general principle, we want to see strong intellectual property systems, obviously in the United States, first and foremost, but we do want to see strong intellectual property systems with our trading partners. The main reason for that is because it helps American businesses doing business overseas. They can engage overseas and sell their wares more confidently if they have a robust system to do so. So we advocate on behalf of of American companies, and we advocate for robust and clear IP rights. I want to mention that also the PTO has attachés across the world. Just for example, in China, we have 3. We have a spot in Mexico, since you mentioned it, one in Brazil as well, by the way, Europe, and so on. And those attachés provide a great deal of information to American stakeholders doing business overseas. They're very helpful, among other duties as well.
Very good. I'm glad you brought up China. It's a big concern, as we all know. I noticed that you cited specific benchmarks for reducing patent pendency in your statement, and considering the virtual full court press by China and other competing nations to expedite their patent approvals, what steps is USPTO specifically taking to reduce the pendency period here, and what recommendations do you have for legislation to address this in order to maintain American dominance in the IP space?
It's a very, very good question, Congressman. It's a broad question.
Sorry.
It's quite all right, but it's a very important topic. So a critical goal for us is to reduce pendency, both overall pendency of a patent application, which is beginning to end to issuance, and also first office pendency and along the way. And we have specific targets, and we're hoping to get below 24 months for the overall period on average, and below 15 months for the first office in the very near term, first office action in the very near term. We want to make sure we hire the appropriate number of examiners to be able to accomplish that. We want to make sure that the time allocation to each examiner per application is appropriately allocated so that they can do a good job, high quality job, but also as expeditiously as possible. Just recently, we reached agreement with the examiner union with respect to a new appraisal plan, and it includes among many other things, special routing, more advanced routing of applications to the correct examiner, and more advanced ways to allocate time dynamically to each examiner per case, depending on factors such as the examiner's qualifications and experience, the type of case, the difficulty of the case, and many other things as well.
The pendency of your answer time is up now, so we got to move on. I yield back. Thank you. Thank you.
Apologies.
At this time, I'll recognize the gentleman from New York for his questions.
I thank the chair and Director Iancu. Thank you for your presence, and thank you for your testimony and your service to the country. It's my understanding that trademark filings have increased significantly over the last several years. Is that right?
That is correct.
And am I correct that since 2014, they are up overall from about 300,000 to approaching 500,000 per year? Is that right?
It's correct on the second part, the approaching 500,000 per year. I don't have the figure from 2014 in front of me, but I'll defer to your figure. It's increased dramatically.
And of course, the USPTO maintains a commitment to issuing quality trademarks. So given this increase in volume, has there been an increase in the number of examiners, or how is that process being managed?
Yes, most definitely. We have increased the number of examiners, and we've done a number of other things as well.
One question about the impact of the shutdown. It's my understanding that USPTO was able to stay open for a period of time, if not throughout the entire duration, because of the reserve that you have as a fully fee-funded agency. Is that right?
Correct. We were able to stay open during the entirety of the lapse in funding.
And at what point would that reserve have run out?
So it differs between the patent operations and the trademark operations. We were approximately a couple of weeks away on the patent side, and I would say approximately, with an emphasis on approximately, a couple of months away on the trademark side.
And at a certain point, it would have resulted in trademark examiners and/or patent examiners being furloughed during the duration had the reserve fund run out. Is that right?
Yeah, probably. If we ran out of funds, we probably would have had to furlough examiners. As I said, patent first, trademark later.
And what would have been the impact, in your view, on inventors, on the innovation economy, on the ability, for entrepreneurs to bring their creativity to life?
It would have certainly been disruptive to the IP, to the patent system in the patent case, and trademark system in the trademark case.
Now, in the event that there's another government shutdown, hopefully there will not be, is there an avenue available for you to access the funding stream that is available based on the fact that you're a fee-funded agency, or is that, as I understand it, prohibited under the law?
Right, correct. Right now, it's prohibited under the law. We are not able to spend fees collected during a lapse in funding. Even though we collect the fees, we can't spend them. But what we can do is what we've done in the past, which is we can spend fees in our operating reserve.
In your view, is this an avenue for exploration in terms of a congressional fix, since, in fact, you are currently accepting fees even in the midst of a government shutdown, but prohibited from being able to spend those fees to maintain your operations?
Well, obviously, access to our collected fees would provide more certainty for continued operations, and should Congress direct such changes as you indicate or provide additional authorities, we will, of course, incorporate those changes and authorities into our contingency planning.
In the brief moment that I have, turning to a different topic, it's my understanding that current law, specifically Section 2 of the Lanham Act, local governments, towns, municipalities, cities are not permitted to obtain a federal trademark registration on things like their flags, seals, and insignias. Is that right?
Correct.
Now, if the government seals and insignias are federally registered, and we're working on bipartisan legislation in that regard, what are some of the protections or enforcement mechanisms that would be afforded for cities or towns or municipalities to protect things like the police department badge, the fire department badge, the state flag, or things of that nature?
Presumably, depending on the content of the proposed legislation, presumably the same remedies available to other mark registrants and owners, including the ability to prevent others from duplicating that particular insignia or flag and the like.
Thank you, Mr. Director, and with that, I yield back.
Thank you. I now recognize the gentleman from the state of Arizona, Mr. Biggs, Representative Biggs, for 5 minutes.
Thank you, Mr. Chairman. Thanks, Director, for being here today. Trademark applications from China have grown more than 12-fold since 2013, and for fiscal year 2017 totaled thousands more than the combined filings from Canada, Germany, and the UK. China's provincial governments are paying citizens hundreds of dollars in Chinese currency for each trademark registered in the United States, likely helping lead to the uptick. To qualify for a federal trademark registration, a product or service must be used in commerce, among other requirements, but little evidence is required to back up the in-use claim. USPTO has issued guidance encouraging lawyers to report suspicious specimens for pending applications. So my first question for you is, since you began encouraging lawyers to report suspicious applications, how many reports have you received?
We have received reports. Unfortunately, I don't have the specific number. I can follow up with that. But we have received a number of them.
Are they, okay, so I'm not trying to pin you down because I know you don't have them. I suspected you wouldn't have them, but I mean, are we talking a few reports or a plethora of reports? Are we talking more than 100, less than 100, that type of thing?
As I said, I'm going to get back to you soon. Here we are. Apparently, we have received approximately 60.
60, okay. Of those, how many applications have been halted or registrations revoked? Any? About 20.
I'm told about 20.
Okay, good. I'm sorry to put you on the spot like that.
That's quite all right.
What direction has been given to examiners as the applications from China have continued to increase?
Well, so we're very much aware of this issue. So what we really want to do is to make sure that our examiners are paying increased attention to suspicious specimens. And it's not just China. It is significant number from China, but any fraudulent applications, we want our examiners to pay increased attention to that. As I've mentioned, we have advanced training coming up just next month. We are providing them with advanced tools, including Photoshop software that can try to detect some of these. I want to emphasize, folks are getting good at Photoshopping.
Right. Well, you know,
and it's getting increasingly difficult to detect.
So, Director, I will say that I met recently with a retailer that has a household name. And one of the things they do is they create in-house brands and trademarks. And they showed me a number of images of successful trademark registrations from peoples and entities from China. That's where they were focusing. They were clearly sloppily photoshopped. And, you know, I looked at it and I said, wow. I mean, I'm just a low-tech member of Congress, and I could tell that those have been photoshopped in. They didn't even make sense. So I guess my question is, how are they getting through? And you just said you got more training coming that's going to help. But how are these things getting through? Are they receiving additional scrutiny, or what's going on?
Yeah, look, I probably have met with the same group of folks you have, and I am aware of some of these. The bottom line is that most of them are very difficult to detect. Now, obviously, some of them should be detected on a cursory view, and some mistakes are made. So in order to, what we want to make sure we do is, A, we reduce the number of mistakes, obviously, and that's what the training is for, and that's what the advanced software is for. And we want to look for ways to be able to detect even those that are currently difficult to detect. So we are attacking the problem from all angles.
So I appreciate that, and I wish you well and encourage you, and if Congress needs to do something, I hope that your team will let us know what we can do legislatively to support that. And I'm running out of time to answer this question, so before I ask this question, I'm going to ask that I have an article from May 5th, 2018, from the Wall Street Journal. I'd ask that it be admitted to the record.
Without objection.
Thank you, sir. And how do you plan to address the thousands of trademarks that are already registered, that are good for 10 years, that may have problems that really are not in use in commerce?
So we want to expand. We have expanded our audit program. So where we go in and we audit existing registrations, as you have just mentioned, and we have just recently expanded that, and we've directed our examiners to increase the number of maintenance filings audited. We have new attorneys specifically attending to this issue. We want to, we have recently piloted an expedited cancellation program, for example. There, in the interest of time, I mean, there's lots of things, more things that we can do. And as I've mentioned in my opening, this is an area where we probably could use some legislative help for additional tools, and we'll come see you all about that.
Very good, thank you. Thanks, Mr. Chairman.
Thank you. I now recognize the gentleman from Arizona, Representative Stanton.
Thank you very much, Mr. Chairman, for putting together this important oversight hearing for this committee. And I want to thank the witness for doing an outstanding job. It's been very educational. My friend from Arizona who just spoke, sounds like we're on the same exact page, and maybe we work together on the legislation that will work with this office, because you're going to hear from me very similar things that you heard from Representative Biggs, the importance of dealing with this issue of the flood of trademark filings from foreign entities, particularly from China. The information I've been given is that in 2014, the number of trademark applications from China was just over 6,000. In 2018, that had gone all the way up to almost 58,000 applications. And I hear you in terms of the difficulty of managing that, but I just wanted to hear us that, I think in a bipartisan way, want to be as supportive as possible to make sure that our American companies and inventors and entrepreneurs aren't being put at any kind of a disadvantage. Have you considered formally issuing examiner guidance that requires additional supporting documents for pending applications to further elevate the issue that we're talking about?
Yeah, so this is a specific issue that we are focused on. So we want to, and we have directed our examiners already. There's already regulation on this issue. So we've directed examiners to more actively use the authority they have to require further proof of actual use of the mark where the submitted specimen raises concerns. And the further training will further emphasize that. It's an important tool that we have and can use more of. There are other things we can do. And what we want to be careful, though, is that we have an appropriate balance here, right? Because very often when you take steps to prevent bad actors, you can sweep in with that, make life much more difficult and therefore costly to the good actors. So we want to have the right balance. I mean, I'll give you an example. We could, right now, so right now, we primarily rely on an affidavit of use. People just swearing that it's in use. Now, as it turns out, some folks are not fully honest. It's shocking, but that's the case. We could, theoretically, require upfront everybody to submit additional proof, not just an affidavit. I don't know, to be frank, whether that's the right approach. It would help reduce the bad actors, but it might impose a heightened burden on all the good actors. So we're considering that, talking to stakeholders, and a whole host of other options.
All right, I appreciate that, and obviously the idea about being in balance, out of balance is important. My impression is that maybe on this particular issue, when it comes to filings from China, we may be out of balance right now, and I want to give you all the support we can as Congress to fix that issue to better protect our American businesses. Now, let's switch gears a moment, just talk about patents. Obviously, you mentioned there are concerns about the Supreme Court's jurisprudence and how it may be hurting innovation, particularly in medical diagnostics, an area where I know we can agree that we should see more rather than less innovation, and a particularly important topic to my state of Arizona, where there are several large biotech companies. Is there a way, in your opinion, to legislatively fix this problem alone through a change to Section 101, or do you think legislation is needed at this point to ensure that those who discover new innovative diagnostics can get adequate patent protection to support the research and development needed to turn that invention into a test that can help patients?
So I believe this is the most important substantive issue of patent law right now. And I believe all branches of government need to work on this. We've done our guidance at the PTO. We're continuing to work on it. But yeah, I think a legislative approach is possible. Look, it took a long time to get here, frankly. The statute has basically not been amended since Thomas Jefferson and James Madison wrote it in 1793. So it's been around for a long time. The problems from the court decisions in recent years has also taken a decade or so to get us where we are. So it's going to take some time to get it right as we move on. We have to move on and get it right, but we want to make sure that, I mean, it's a complex issue. So we want to make sure that we study it carefully and speak with our stakeholders, consider all points of view. There's certainly a path forward, and our guidance illustrates a particular path. There is a legislative path as well, and we just have to make sure we're deliberate and careful about it.
All right. Well, if we can improve upon Jefferson and Madison, I guess we'll give it our best shot. Thank you very much, Mr. Iancu, and I'll yield back.
Thank you.
As I recognize Mr. Jordan, I'll just comment on the fact that insofar as fraudulent trademark applications are concerned, we're working on legislation to address that problem, and I'll be looking forward to working with all members of the subcommittee to make sure that the legislation that is crafted is suitable. And with that, I will yield now to the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Chairman. Director, I got two questions. One is one that I want to ask. The second one comes from a colleague, Congressman Massey, who is not a member of the Judiciary Committee. It's unfortunate the rules of our committee don't allow non-members to ask questions, particularly in this case where Mr. Massey, the holder of like 30 different patents. So let me start with mine. I'll read it and then we'll jump to, and it deals with the IPR process and PTAB and some of the things that were part of, obviously, the American Events Act. One of the major changes brought about by the American Events Act was the creation of IPR. We created this process in an attempt to help guard the patent ecosystem against patent trolls and to prevent them from disrupting innovation and devaluing inventions. Based on the data released by the PTO in March, it seems that the IPR system is largely working. Of course, some patents are struck down in the IPR process, but courts also strike down certain patents. The IPR system appears to provide a more cost-effective way to get an expedient way to deal with this issue. Over the last year, you guys have made some changes to this process, which include changing the claim construction standard, changing the process for claim amendments, and issuing multiple precedential decisions on why IPR shouldn't be instituted. I'm curious as to why you felt those changes were necessary. But let me hone it down even a little bit more. The Trump administration has made it a high priority to tackle the rising cost of prescription drugs. Obviously, patents are a cornerstone of the incentive to make life-saving drugs, but everyone can agree that this grant should not be abused, which is why we have checks and balances in the overall patent system. The bio and pharmaceutical industries have made no secret about the fact that they do not like the IPR process. In fact, they've sought a carve-out, which causes me a little concern because if you're going to do it for one industry and not others, I think there's some concern there. Question: do you have any suggestions for Congress with respect to things we should do to make sure that patents in the pharmaceutical space correctly balance the rights of the inventor, the incentive to invent, and the rights of competitors to enter the market? And secondly, can you please tell us the status of your changes to this process and any effects they may have?
Excellent. All in 2 minutes and 38 seconds. Very good.
You got to do it quicker because I got another question from Mr. Massey, and he's sitting in the audience and he wants me to get to it.
Well, where to begin?
You can. I'll take it in writing. Well, let's do this. Let me ask Mr. Massey's question, and then I also want to submit a couple others to you to look at for Mr. Massey, and then you can say what you can in 5 minutes, and you can give the rest of it to me in writing. Would that work?
Very good.
Mr. Massey's question deals specifically with PTAB. He says this: the PTAB was supposed to provide experts to review patents that were mistakenly issued. Why are so many patent claims invalidated by the PTAB if, in fact, the Patent Office is issuing valid claims? I think he gave me a number of like 84%, which seems really high. I don't know if that's accurate, but that's what Mr. Massey conveyed to me on the number that are invalidated.
Okay, very good. So just quickly on this point. There are two major steps in an IPR process. One is the institution decision. So once a petition is filed, we need to decide whether to institute the proceeding or not. Mm-hmm. So a good number of petitions do not get instituted. So those drop out, we don't cancel them, we don't change them, they're not in the process at all, so the patent remains valid as far as the PTO is concerned. Once it's instituted, The number overall is approximately 80%, Mr. Massey is right, on balance overall, on average, I mean, once the proceeding is instituted. When you combine those two numbers, the percentage of patents invalidated is significantly lower.
What's that number?
It's in the 30-40% range, and I'll get to it in a second as I keep talking. But the fact of the matter is the patent process is never perfect. Obviously, courts, we're dealing with words here and concepts and so on. So courts invalidate themselves 35% of the patents, give or take. It should not be surprising that with a lower standard of proof, which we have at the PTO legislatively provided, so lower standard of proof to invalidate the patent compared to courts, not surprising that we would invalidate at least at the rate the courts do.
Which is what you said, 30 to 40, you said you're about 40?
Yeah, so we're overall.
Once that threshold.
Correct.
Yeah, okay.
When you combine the two.
Right.
Okay, so just to go back to okay. Sorry.
If you can get to me right, and I would, if I can, we'll get you the other questions from our colleague, Mr. Massey, as well.
Second round, however. And with that, I'll now move to the gentle lady from California, Congressman Lofgren, for 5 minutes.
Thank you very much, Mr. Chairman. It's good to see you again, Director.
Good to see you.
Last time we saw each other, I had a terrible cold, and I hope you didn't catch it from me.
Well, we'll have a separate discussion.
Sorry. I wanted to talk about FRAND. The Department of Justice in December indicated that they were withdrawing from the 2013 policy statement on remedies for standard essential patents subject to voluntary FRAND commitments. And it's been reported, but I don't know if it's accurately reported, so it's a question to you, that the Department of Justice wrote a letter to the USPTO asking the Patent Office to withdraw from the policy statement. Is that true?
I have not seen such a letter from the, we've received letters from the public and stakeholders, but I haven't seen a letter from the Department of Justice.
Okay, well, that's good news, because I think that would be highly inappropriate, honestly, but I don't always necessarily believe what a press reports I wanted to see. I do think, and I assume that you agree, or you'll tell me if you don't, that fair, reasonable, and non-discriminatory licensing obligations are really critical to encouraging the adoption of cutting-edge technology, interoperability, and giving consumers choices.
I agree with that.
Very, very reassuring. I wanted to talk about patentability. We've touched on some of this. Section 112 written description. Your review, as I understand it, and you'll correct me if my understanding is wrong, that the Section 112 guidance you gave focused on software inventions, but not the life sciences. Is that correct?
In the Section 101 or 112?
112.
So in Section 112, in the guidance we issued, so we issued two pieces of guidance in January at the same time. One is on 101, same day we also issued on 112. In the 112 guidance that we issued that day, it was focused on computer-implemented inventions.
Okay, because it seems to me that the life sciences needs as much attention. Theranos, the blood testing company whose founder is being investigated for fraud, was granted nearly 100 patents based on an invention that didn't work. And it concerns me that a patent application for an invention that doesn't work gets approved. Professor Grimmelman, I'm sure you've heard this, of Cornell Law, said this, that the USPTO is an armory handing out legal howitzers on the honor system. What could possibly go wrong? And I think the Theranos situation is a good example of that. So I guess one of the questions is, how do we enable, how do we Well, maybe what the underlying question is, what percentage of time do examiners actually spend on 112 analysis? How do we make sure, I mean, one has to be skilled in the art to practice the invention. How would we demonstrate that the applicant actually invented what is claimed in a situation like the Theranos case or others?
Right. So I don't have off the top of my head the percentage of time in each one, but of the statutes, examiners examine for compliance with all the statutes, 101, 102, 103, and 112. And we want to make sure that examiners hold applicants accountable on all of them. 112, so for life sciences, 112 is important. Frankly, 103 is at least as important there as well, because we want to make sure we don't give patents on innovation or on applications that are mere obvious variations, and sometimes that's difficult to detect, so we want to make sure the examiners are well trained on that. We are providing training all the time on these issues, and now increased training, especially in the tech center that has to do with life and pharmaceuticals and biotech inventions. In June this year, for example, examiners will receive updated training in Tech Center 1600, which is exactly on these types of patent applications. So we're very focused on this issue.
Okay. I'd like to follow up a little bit more later, if we could, on this issue, because, you know, I am out of time. But I do thank you for being here, and thank you very much for your restatement of commitment to the 2013 policy statement. I think that's very important. I think it's a mistake for the Department of Justice to have done what it did, leaving us just with the FTC and the International Trade Commission, but there we are. I don't always agree with what the DOJ is doing these days.
If I can respond briefly to that last point. Okay. So just briefly, DOJ did withdraw from the 2013 policy statement. The PTO has not yet made a statement on that. We are studying the issue now that the DOJ has withdrawn, and we hope to have a view on that soon.
Mr. Chairman, could I ask for, I will forego my second round if I can, because I thought I heard you say that you felt that, or believed that the FRAND was important to innovation. Was I incorrect on that?
No. I fully believe that FRAND is important, and we, especially in FRAND encumbered's standard essential patents, we want to make sure that we encourage good faith negotiations between the parties, between the licensors and licensees and the like. Good faith negotiations to reach a FRAND decision, critically important for innovation and implementation and the like. I agree with you on that. My only point was that is with respect to the 2013 statement, PTO has not yet taken a position on that particular statement in light of the DOJ's withdrawal.
Okay. Thank you, Mr. Chairman.
Thank you. I now recognize the gentlewoman and ranking member of this subcommittee, Alabama Representative Martha Roby, for her 5 minutes.
Thank you, Chairman, and Director Iancu, thank you for your grace as I had to exit to go take a vote in appropriations. But I want to talk about counterfeiting. It's been an increasing problem, so much so that the President issued a memorandum last month instructing several departments to provide a report on the issue and recommend actions to combat the problem. As the head of the agency responsible for registering trademarks in an agency participating in the administration's efforts to combat counterfeiting, what insights can you provide on the state of counterfeiting online specifically, and what can the administration and Congress do to address the increase of sales of counterfeits online?
Thank you for the question, because it is a critically important area. The short of it is the state of counterfeiting online is not good. There is a huge, shall we say, tax on American businesses as a result. I should say that approximately 85% of the counterfeiting comes from China and Hong Kong. But overall, all counterfeiting is a huge problem. The administration is paying very close attention to this. You've mentioned the presidential memorandum on this exact issue. The Department of Commerce is tasked in conjunction with the Department of Homeland Security to work with the Department of Homeland Security on this issue. The PTO is heavily involved on it. So at the PTO, we have a lot of knowledge on this, a lot of experience and expertise, and we do have done and continue to do a lot on it. We take a lot of action on it to the extent we can. So, for example, coming up just in a few days on June 6th, we're going to have an all-day public forum at the PTO headquarters entitled Brand Protection and Anti-Counterfeiting Strategies, conference with experts and the like. We just recently conducted a video contest for public service announcements called Consumers Combat Counterfeits, where children at different grade levels and the like created very, very creative public service announcements and submitted them. There was a contest and we announced winners, I think last month. We work with the National Associations of Attorneys General across the United States for training workshops and capacity building and the like. In conjunction with the Department of Commerce, we have a stopfakes.gov effort. We work with many other agencies, the IP Enforcement Coordinator, the National IP Rights Center, the Border Patrol, the USTR, and others to address this issue. We take steps internationally. We advocate. When we travel internationally, we advocate strongly on this issue on behalf of American companies and our interests. Anyway, I'll stop there, but we do a lot.
Well, I would just say, and I understand what you're doing in my short time on this committee, I've become aware of how serious this issue is, and so I would just ask that the chairman and that we can continue to work with you and figure out if there are ways that Congress can be more proactive, think outside the box, have real conversations with all the stakeholders, and I look forward to continuing to work with you on that.
And just briefly, the presidential memorandum requires a report that we're working on across government in a few months, part of which would be legislative recommendations as well.
Perfect, thank you. And at our last hearing on patenting by women and minorities, the witnesses testified that it was very difficult for inexperienced or pro se inventors to find the availability of several free patent assistance programs administered by the PTO. So I'm going to give you this opportunity to tell us, because I know there's been things that have been done to help inventors locate the sources of assistance to help them navigate this very complicated patent system.
Thank you. And we have just recently, among other things, revamped our website. It's a much more user-friendly and modern-looking website right now, but a key component is at the top, very prominently displayed, is a section for new to IP, patents, trademarks, and then a button you can click for Get Help in your area. You click that, it goes to a map of the United States, and you can click on your state and specific resources in your state. For example, across many states, we have resource centers, patent and trademark resource centers located in libraries, usually on a university campus, and they're heavily, they're specifically for individuals who want assistance, so they can go there, you can find out where it is. We have a patent pro bono program, for example, heavily used across the country by folks without appropriate resources. I happen to have some statistics here that says that 60% of those who applied for pro bono assistance in 2018, this is a study conducted by Georgia Patents, by the way, 60% who applied were women, 58% who applied were minorities. There's obviously overlap and the like. So there are quite a few resources available.
Thank you, and Mr. Chairman, I'd say that's a pretty positive outcome from the hearing that we had, and we appreciate your attention to it, so thank you.
Thank you. Next, we will turn to the gentleman from California, Mr. Correa, for 5 minutes. Questions?
Thank you, Mr. Chairman, and thank you for holding this most important hearing. And I want to thank our Director, Andre and Iancu, for being here today. I wanted to follow up on some of Ms. Roby's questions regarding the fraudulent trademark applications, primarily your words 85% from China and Hong Kong. What are the repercussions? So you filed something that's fraudulent. Are the Chinese government, folks from Hong Kong, working with us to reduce this, or is this just something that happens in the U.S. and we have to live with it?
The 85% number that I mentioned to Ms. Roby's question was with respect to counterfeiting and pirated goods entering the United States. I think your question goes towards the fraudulent trademark applications
yes, that's
filed.
correct.
Yeah. You know, I don't know if the Chinese government is cracking down on this, frankly.
Would this be part of the trade negotiations that are going on right now?
IP in general and the abuse of the IP rights of American companies certainly is a significant component of the
Would Trademark be part of that, or we just?
Well, look, I don't know if it rises to the level, but it is a very important, it's an important issue. Hopefully that will abate.
For this committee, I think, and for your office as well. So
yeah.
What do we do to elevate this to a level that maybe people pay attention to this?
Well, we speak about it all the time, and I speak about it all the time. I advise.
So how do we, I understand that, so how do we get it to the level that people listen to us, that are involved in these negotiations?
So the people involved in the negotiations do know.
Write a letter to Mr. Lighthouser and explain to him that this is an issue that's important.
Ambassador
You
Lighthouser.
called it an indirect tax, and I think you're absolutely right, on Americans.
Yes, Ambassador Lighthouser knows about this issue.
Okay. Following up, also, we talked about the complicated patent system that you have. Are you implementing the technology in a way to simplify this so folks can better navigate through the system online, or is that even a possibility?
It certainly is a possibility. So we, as I've mentioned, we just recently revamped the website to make it a bit easier. Having said that,
It is easier or a whole lot easier?
It's, you know, it's a complex system.
Is it complex because of the technical or just the legal aspects?
Yeah, the legal aspects are very complex. I say sometimes that there's a statute someplace in the codes, like 101.5, that seems to say that patent law shall be complex somehow. So, but we try to do the best we can to simplify it for folks. And I want to emphasize that for individuals, folks who cannot afford lawyers and the like, we have a pro bono program. In addition to that, we have a pro se dedicated workforce at the PTO itself. So if you appear pro se without a lawyer and you need help to navigate, we have dedicated examiners who will answer the phone and guide you through the system. And I think that sort of personal connection is probably the most helpful.
I know we're planning to have some events in my district to highlight the good work you do and how you can help local economy by helping local entrepreneurs. I'm hoping we can have a segment where you touch upon these kinds of services that you provide to our local constituents when you're there.
Hopefully, and I look forward to that, by the way.
Thank you very much, Mr. Chair. I yield the remainder of my time.
Thank you. And next, we will recognize the gentleman from Virginia, Mr. Klein, for 5 minutes.
Thank you, Mr. Chairman. Director Iancu, thank you for being here today. I want to return to the issue of drug patents. My constituents are very concerned about high drug prices, and And many critics of high drug prices would argue that one of the problems is drug companies filing and being awarded multiple patents at different times, some representing very minor improvements. And they argue that the practice of filing countless patent applications covering a single drug contributes to patent thickets and leads to a process called evergreening. Do you believe that follow-on patents should be granted for trivial and obvious modifications to the original drug patent, and in what circumstances might that be appropriate?
It is never appropriate to issue patents on obvious variations of prior inventions. So 35 U.S.C. Section 103 says that you cannot get a patent if it is an obvious variation, and the key, obviously, is the implementation and application of that. Our examiners are trained on that issue, and specifically for pharmaceuticals, we're about just next month to provide, yet again, advanced training in that specific tech center on the obviousness question, because it is a critically important issue. We want to achieve the right balance when it comes to patents on pharmaceuticals. Innovation in the pharmaceutical space is critically important, obviously. Creates products that saves lives, improves the quality of people's lives and the like. At the same time, we want to make sure that the patents that we issue comply with all the statutory bases, and critically important, that they are new and innovative, and that they are not mere obvious variations.
I'm glad to hear that you're introducing additional training for examiners, and that will help keep track of all the related applications that are filed. And I understand that while patents can be granted to the drug product, a better method of making a known drug, a new way of administering a known drug, and using a known drug to treat a new disease, do all of those different forms of inventions justify granting 75, 100, or even more patents?
It certainly depends on the drug, and if there are innovations on all those areas, there can be multiple innovations in each one of the areas that you have mentioned and others. For example, there can be innovations on the use of a particular formulation. So new use of old drugs, that can be very innovative and usually requires significant investment and research and development. I'll give you just one of many examples. The well-known drug AZT, which was more or less a failed cancer drug. After additional innovation, it was discovered that it's a very good drug for the treatment of AIDS or HIV. And that was based on further innovation. So there are examples like that, and it really depends on the particular drug and application. Critically important, though, is that for each application that we see, we have a rigorous process that we go through, and we make sure that the application in front of the examiner actually presents novel and non-obvious innovation for claiming vis-a-vis what's come beforehand.
I understand you have to achieve a balance, but I'll give you an example on the flip side, and you tell me whether this is a problem beyond this example. One report indicates 95% of all the patent applications on the diabetes treatment Lantus and insulin analog were filed after the drug was first approved and on the market in 2000. It's argued that together the patents result in a 37-year period of exclusivity. Can you explain why the PTO would allow one pharmaceutical company to obtain so many patents and potentially double the exclusivity permitted in the Patent Act, which does limit patent terms to 20 years from filing, but allow for short extensions for FDA delays?
So I'm not familiar with the specific product you mentioned and the patents on it. Again, it really depends on what they have filed and the innovations that are appropriate there. The 20-year exclusivity period is from the time of invention to expiration of a particular patent. It's entirely possible for any product, whether it's in the pharmaceutical area or the cell phone area or anything else, that innovation occurs later. So obviously you have a particular drug that's been out for a number of years, a lot of new information comes about, and new innovations, so I'm hypothesizing now, again, not specifically to the one example you gave because I don't know, but it's entirely possible that based on the information that was collected during the time the pharmaceutical was being administered, new developments were made with respect to the dosage or the delivery mechanisms that make the drug more potent or has less toxicity, for example. Those could be critical innovations that change that improve the quality of life of the patient at issue, and it could be innovative. It could be novel and non-obvious compared to the prior innovations, and those could happen later. So it depends on the particular application.
And my time has expired, but I think we also have an interest in ensuring that a greater number of people have access to generics and the availability of drugs, so we have to maintain that balance as well. So thank you. Yield back.
Thank you.
Thank you. I'll now recognize myself for a second round of questions. Mr. Iancu, I've heard concerns about repetitive challenges to the same patent at the PTAB. On the other hand, I have heard the concern that if multiple entities are accused of infringing the same patent, each one should be able to petition the PTAB to reconsider whether the patent should have been granted. Which of these two groups has the better argument, and how is the USPTO currently balancing these concerns?
So the balance is the key. We want to make sure that petitioners have a fair opportunity to challenge a patent pursuant to the AIA, given the statutory mandate. But at the same time, we want to make sure that patent owners are not harassed. So we want to make sure that we have a flexible approach that can be deployed in each case based on the facts and circumstances of that case, but in a consistent and predictable manner. So what have we done? We have developed a set of factors that addresses follow-on petitions. It came out in a case called General Plastic, so we call them the General Plastic factors, for lack of a better term. And if we see a follow-on petition, a petition filed after the first one, we go through the factors and see whether it makes sense to, for the system overall to have yet another petition on the same patent. We're also looking right now at not necessarily what's called serial petitions, but the multiple petitions that are being filed at the same time. There are situations, 85% of patents have only one challenge, only one petition that we see in IPR. But for the other 15% of patents that get challenged, we see multiple petitions, sometimes at the same time. So we are looking under what circumstances that makes sense. And we want to make sure, again, that we achieve the proper balance.
Thank you. I will now yield to Mr. Klein if you have any other questions.
Mr. Chairman, thank you. I've exhausted my list of questions.
Thank you. Mr. Correa? Well, with that, I think we can conclude this hearing. I want to thank the gentleman, Director Iancu, for your appearance today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is adjourned.
every way, shape, or form.